This is a video concerning Iowa unemployment compensation. It is a nonprofit video. It's not sanctioned by Iowa Workforce Development, all from volunteer time. The information presented is legal information, not legal advice. Now, today's topic concerns how to participate in a fact-finding interview and how to appeal from a decision of a fact finder. First of all, the fact-finding interview is very short. It is not a due process hearing, which means it is not recorded. The parties are not under oath. The best way to prepare for a fact-finding interview is to have all the information in front of you at the time the fact finder is to call. You may have to wait some time. They don't always get calls at time. Be ready. Make sure your cell phone is charged. Preferably, if you can, have a landline as your official phone number. And if you will have an opportunity to send some documents in. If you have documentation, send it in. Don't overwhelm fact finders. They don't have a lot of time, but send in what is necessary. You should, if you have a tendency to be tongue-tied or get scrambled in your thoughts while in a discussion, it doesn't hurt to sit down and write out what you want to say, the pertinent parts of what you want. Remember, the fact finders have to do a lot of interviews. They don't take detailed notes. Usually a couple of paragraphs is all they get from a fact-finding interview. So you must be summary in nature. You must have the information and facts in front of you and ready to go. It's very important that you are well prepared for a fact-finding interview. Now, as far as employers go, it's also important that employers participate. Some employers simply skip fact-finding interview because they'll know there'll be a hearing before an administrative law judge if they won't lose and they want to appeal. Unfortunately, the law has an exception to overpayments when employers do not participate in fact-finding. If it's a quit or a discharge issue and a claimant wins at fact-finding, and the employer failed to have any meaningful participation, then if the case is reversed, the overpayment does not go to the claimant, it goes to the unemployment compensation fund. So everybody ends up paying for that claim when one employer doesn't participate. So it is best if everyone participates. It is best if everyone is well prepared, both claimant and employer. Now, after you've done with your fact-finding interview, the decision will come out, and I've pulled up a decision, taken out the information from personal information. It might be kind of hard to see, but you can see what the format looks like of a fact finder decision. The key part to keep in mind of a fact finding decision, much like many of these cases, is that you have an appeal deadline, and it says to appeal this decision. This decision becomes final unless an appeal is postmarked by October 9th or received by Iowa Workforce Development Appeal Section by that date. If this date falls on a Saturday, Sunday, or legal holiday, the appeal period is extended to the next working day. It is imperative that if you feel that you have lost on your fact-finding case, that you get an appeal on file by the date specified. If you miss that date, you'll have the burden of not only proving your case, but proving that your appeal is timely and that your late appeal should be excused. So when these come in the mail, don't let them sit. Make sure you read the part about when the due date is and get your appeal on file if you feel that you've lost. Now, sometimes one of the big mistakes that happens is parties will appeal favorable decisions. And it's all right to appeal a favorable decision as long as you correct it once you find out that you won. And if you appeal a favorable decision and then later find out that you won, you need to file a withdrawal. And that's quite simple by calling the number on the hearing notice and say, I want to withdraw, or sending a letter in saying, I want to withdraw, signed and dated. And either party can withdraw right up to the time of hearing. If you go into a hearing on a case that's favorable that you appealed, that is, if you appeal a favorable case and go to hearing, it can go against you. Just because you appeal a case that went in your favor doesn't mean it can't go wrong at the time of the administrative law judge hearing. Now, how do you appeal a fact finder's decision? Well, this decision comes in the mail. Probably the easiest way to do is simply take this decision, write on it, I wish to appeal, sign, date it, and then mail it in, fax it in, or whatever, and make sure you keep a copy and proof of the date of mailing, because these things do sometimes get lost, especially around holidays. So always keep copies of everything that you send workforce development. And you might as well start creating a file once you start an unemployment claim if you're a claimant. And if you're an employer, you probably have a personnel file. Get these things filed and keep them available so you know where you stand on the hearing without having to dig for documentation. Do you have to have grounds on the appeal? Well, not necessarily. When you file an appeal simply by stating I appeal, that's enough. But correspondence should always include the claimant's name, claimant's social security number, and the original claim date, as shown in the upper corner of this fact finder decision. Also, how to appeal, and that may change over as time goes on, and I'm not going to get into the specifics of how to appeal, but the appeal information is usually inside, and follow those instructions carefully, and you'll have no problem. Again, just making a copy of this document, writing on it, I appeal with your name and date is usually sufficient, and as long as it's mailed to the right place or faxed to the right place. But keep copies of those fax transmission sheets, because these things don't always make it to where they're supposed to go. And that is it in a nutshell. When you have these cases, oh, one more thing I guess we need to talk about. These decisions sometimes come late in the mail, and they arrive after the due date. If they arrive after the due date, you should immediately document on the decision itself that the document came on this particular day. That way you have a record of when it came in the mail, and then you should immediately, the same day if possible, file your appeal if you believe that you lost. Don't delay for a minute if this came late, because it is excusable if there's a delay caused by the U.S. Postal Service. It's not excusable if there's a delay caused by the Postal Service followed by a delay when you just couldn't make up your mind if you wanted to appeal. So remember, as with all workforce papers, all unemployment papers, read the entire document word for word. Read it over and over until you understand it. If you don't understand it, contact a local workforce representative and ask your questions. Always be ready for the fact-finding hearing with all documents and all information in front of you at the time the fact finder is to call, and you will be far better off on your unemployment claims. And that's all I have for this. The next, I'll address appeal procedure before an administrative law judge in a later video.